Pardon to mention, my lord. Memo, my lord, 11-year in custody, my lord, that is for bail, and one is hearing, my lord. One is hearing more than 13-year in custody.
10 years. 9 years in custody, I filed with bail.
Give it.
Pardon to mention, item 39 weekly list. After that, this matter will be taken up on Monday, my lord.
No.
The vote has not been prepared, and I have also not got the serological report on the paper book, my lord.
No, we have.
Serological and the chemical report has not been received.
You see, that's a part and matter. Everybody must be under impression that that will continue. So, any other matter is ready.
We'll start the death reference, my lord.
Hmm.
Item 6.
But once the death reference starts,
the-
this matter will not be.
Yes, ma'am.
You have
On
already
Monday,
placed. You have already placed. No, Monday we have other cases. Another death reference is fixed to Monday.
tomorrow.
No, you place the matter. We'll see that file.
What a password flavor.
Hold on. Daki then.
Weekly list password item number 11.
My pleasure, lords. This case one last occasion you received direct to State Council for obtain instruction regarding the criminal antecedent of the appellant, my lord.
So, what is your instruction, Mr.
Last page. Last part 1. Second page is last part. Regarding the criminal antecedent, there is no antecedent. And so far, the law and order situation is that is last para.
One of the accused has been released on bail.
Yes,
Jai Mangal Pradhan.
yes, my lord.
So, how many persons face trial?
Lord,
Of 7.
my lord, 7%.
That Jai Mangal Pradhan is accused number 5.
Yes, my lord.
Okay, that's in the trial court. Jayamangal has also been found guilty under 376D, 120B, and sentenced to imprisonment for life, along with Unna Oram, Prashant Dandashana, Ranjan,
Vishnu
and
Kisan.
Vishnu. They are they have filed the 4 appeals. and he has also been found guilty under 66E of the IT Act, 67B, then so major offense, he has also been found guilty. So whether there is any distinctive features.
Just a minute, just one.
Hmm.
No, 1 minute.
Who is the victim in this case?
Victim is the one of PW1. Priyadarshini Nanda.
My lord.
Hmm.
6 that Jairam Mangal, my lord. In that case, my lord, okay. तेईस 7/2016 he has been released.
No, have you verified the statement of the victim?
No, my lord, not very bad.
You see, perhaps that man who has been released on bail,
My lord,
he was the auto rickshaw driver.
my lord.
He has not actually participated in that.
Yeah, he took us
Uh,
only for drive.
thereafter, so his role is completely different than this persons who have
Putting on
preferred
the
appeal.
regiment.
He appears to be in 120B, but
Mhm.
not a direct assailant, direct culprit.
And say paragraph 4 or last line ne dekhun se kouchi, the accused in white and black striped shirt, accused Jay Mangal, is the auto driver who took us to the dike. କାରଣ ଡାଇକ୍ ପରେ ସେମାନେ ଚାଲି ଚାଲି ଯାଉଥିଲେ ଯେତେବେଳେ ଘଟଣା ହେଇଛି।
ଚାଲି ଚାଲି ଯାଇ ଗୋଟେ ଗଛ ତଳେ ବସିଲେ,
ହଁ
ତାପରେ ସେମାନେ ଆସିଲେ।
ହଁ ଅନ୍ୟମାନେ ଆସି ସେ ତାପରେ ସେ ରେପ୍ ଆଲିଗେସନ ତାପରେ ଆସୁଛି। ତେଣୁ ସେତେବେଳକୁ ଇଏ ସ୍ପଟ ରେ ହିଁ ନଥିଲା, କାରଣ ସେ ତା ପୂର୍ବରୁ ଛାଡି ଦେଇ ପଳେଇଛି। So you are in which item?
Item 721.
721 Munna Ora.
Yes, man.
So what role has been attributed
My
to?
lord, in this case, Munna Oran identified by PW1
No, as what is the role played by?
Role, my lord, he is told the friend of the victim, that is PW4.
Wait, let us see. The paragraph come to paragraph number
4, my lord.
No, 4 you leave it. Munna Oram. The other two and the accused one. So, paragraph 4 पढ़ो.
My lord, I am reading, my lord. The person in black shirt identified Vishnu Kishan and another told me, and the other is not facing trial in this case. The other two in blue T-shirt identified the accused Munna Oram, and the accused in blue shift shirt, accused Ranjan Oram, have caught hold of my friend Amrut. The person who put in a white napkin on his face and directed the accused person to take me into the place as per the direction in blue color check shirt, as she identified the accused Prashanta Dhansanama.
Chief on Prashant Donsana direction dala.
Yes.
ताकू नहीं जा. Then
This accused in white and black shift
ठीक
shirt,
बोला.
accused Joymangal, is the auto driver who took us to the dike.
तापरे 5 number paragraph.
These two who caught hold me took me the distance, and therefrom they again took me to another place. As they found those places not suitable for commission of sexual intercourse, therefrom I was taken to another place. Thereafter, the accused, whom I identified today, Vishnu Kisan, along with other one who is facing trial before the Juvenile Justice Board, made me lie on the ground under down surface. Subject to possible sexual intercourse despite of my resistance. The accused Vishnu Kisan first committed rape on me, and another one is taking snap on his mobile. Similarly, after Vishnu Kisan rape on me, the other one juvenile Amir committed rape on me. The accused Vishnu Kisan was shooting the picture on his cell phone. In between, someone came to the spot and told something of those two and left the place. I cannot say who was the person. In between, the accused who had recovered his face by napkin, accused Prasanta Dhansana, come twice to wooden the act of this accused person. The napkin was
To
used.
watch the act.
Yes, ma'am. This napkin was used by the accused Prasanta Dhansana to cover his face, marked as MO1. After 15 to 20 minutes, I found some person of the nearby village, 5 to 6 person, and also my friend Amrut came to the spot. At the sight of them, these two, Vishnu Kishan and the juvenile, fled away from the spot. While they are fleeing away, the accused Vishnu Kishan told me that he could have caused something more serious damage to me, but because of the presence of the villager, he left me safe. Thereafter, I and my friend Amrut, on being led by the villagers, would find the approach road and came from the jungle to the road. The auto rickshaw, along with the driver by which we had been to that place, was still awaiting us there on the road. The villager who led us to the road by showing the approach road left the place, so myself and my friend Amrut to Antapalli Chowk in the auto rickshaw, which was driven by the accused identified as Jayamangal Pradhan. I myself and my friend Amrut reached Antapalli Chowk at about 12 noon by the said auto rickshaw. Amrut got down and left for Rengali and paid the charges to the driver of the auto rickshaw and told him to leave me at overbridge. Accordingly, the auto driver brought me to overbridge just near GM College by this auto rickshaw. I stepped down from the auto rickshaw and proceeded to my home at Modipada.
Continue. Paragraph 6.
Para 6, my lord. On the way, the accused were asking me if
Accused means the person who has been released on bail.
Yes.
yes, my lord,
Auto driver. Yes.
asking me if anything has gone wrong with me. He also somewhat asked me as to what happened with me. So also made query if those person who came to the spot have assaulted me. He was also asking about all the details as to how many culprits were present there, but I did not answer to any of the questions. On being scared of the situation, I could not divulge the fact to any of my family members, my parents. I, as usual, continued to go to college from the next day. The incident took place on Tuesday, that is 22nd July 2014. After 1 week, 13th July 2014, I was attending the class in chemistry laboratory of GM College and after completion of the class, when I came out of the laboratory and about to go to my house, the accused, who on the very date of incident covered his face with napkin, the identified accused Prasanta Dansana, came to me in between 12:30 to 1 p.m. He first asked me to identify him. When I told him that I failed to identify him, he reminded the incident and told me that he was the said person present during the incident. He then requested me to join him at Metagani temple to offer some puja as my days and not going well. I refused his request and asked him to why he is after me. On my refusal, the picture of sexual intercourse which was committed by the accused person taken on cell phone was shown to me. When I was asked him as to why he has kept his picture on his cell phone, then the accused Prasanta Dansana assured to delete the same if I would join him. I did not listen him but proceeded to my home in another way. Paragraph 8. 2 to 3 days after it, he again came to my college on the scheduled time in between 12 noon to 1 p.m. and approached me to what I avoided. He again came on the next day and approached me at the same time in between 12 noon to 1 p.m.
That evidence is against that Prashant Dansana.
Yes, my lord.
Yes.
The off hour of my college. On that day, also I avoided him even if he approached me. Thereafter, he never disrupted me till I could not know about the MMS. I found
live streaming করলে
Item number 14.
Please, your lords. Who the one? The appellant in the opportunity of appeal.
What is your good name, Learned Counsel?
Pradeep Kumar Pradhan.
Okay. So you were not present yesterday, even day before yesterday, you were not there. Okay. You have filed your VNAMA without the consent of so and so. VNAMA টা টিকে দেখি না? ସୁନିତା ବିଶ୍ୱାଳଙ୍କୁ କଣ ମାନେ ଏନଗେଜ କରାଇଥିଲା କୋର୍ଟରେ 1/5/18 अच्छा सुनीता विशाल and counsel is hereby appointed for conducting this appeal. ताहले ये तो रेगुलरली चला और still be released still be left. As per order dated 1/5/2018, this court appointed Ms. Sunita Biswal as the advocate to conduct the case for the appellant through the Legal Services Authority. Okay. Since the appellant has engaged Mr. Pradeep Kumar Pradhan and his associates to conduct the appeal, and Mr. Pradhan and his associates have already filed VNAMA, the name of Ms. Sunita Biswal shall not be reflected in the cause list henceforth. Yes, sir, you can argue the matter.
Let me next week.
Acha,
File টা return ହେଇଯାଇଛି ଆଟା ନେଇଛୁ
Monday ରେ ତ ଆସିବ? ଆଚ୍ଛା ତାପରେ ଲେଖି ଦିଅନ୍ତୁ the Learned Counsel for the state seeks for an adjournment till Monday, next Monday. Put up this matter in the week commencing from 1st July 2020.
Item 39.
Yes.
Please, your lord.
So you are in statement of PW4.
PW4, your lordship may kindly see the cross examination of PW4.
Right.
In cross examination, PW4 stated that the witness Kasni was found running away kite. My house is half kilometer away from the spot. When we reached the spot, found the dead body inside the house. No other persons were available in the house. The weapon of offense Gagada is generally available in the local area. The accused was found carrying the gunny bag containing some rice. The house of Debojani and Chatri are adjoining to the house of the deceased. When the witness Ghasni raised Hulla, by the time her father was at distance about half kilometer from my house. The serpent of the village reached on the day at 10:30 a.m. On the very day, the police took the incriminating articles. On the very date at 11 a.m., the police arrested the accused. I did not go to the police station in connection with this case. The police prepared the document at 4 p.m. and obtained my signature. It is not a fact that I have not stated before the police that the accused concealed the weapon of offense inside the court shed. It is not a fact I am deposing. My respectful submission is that PW3 stated that she came outside the house and raised halla. The PW4 came and also villagers came. But in the cross examination, PW4 did not support the statement of PW3.
What did he say?
He says that he was half a kilometer. How can a man?
No. Did he dispute that having heard the cry or the shout, he has not come? How did you say that he did not support? He has said that on hearing the hulla, I have come.
How
What is
can
the
one
distance
man
of half?
this
No, no,
half
no.
kilometer
Sir,
distance?
that is a different thing. You are saying that he did not support. He has supported. How he came, that you argue. But you cannot say that he did not support. He supported.
He also stated that no villagers were present.
Yes. By the time
By the time he
reached,
came, was no villagers were
how
present.
can you say? Is it
He alone was present. Also, PW5 stated that in his cross section only PW4 was present, no villagers were present.
correct? That means it's correct position. So PW4 is correct. By the
PW
time PW5 was came there, he
Yes.
saw only PW4.
4. No
And
villagers were
PW4 has
present.
not seen anybody else. Correct. By the time he arrived, none was there. PW5 has come later. He's correct.
So they are not the witness to the occurrence.
Why?
They are,
They are not witness
yes,
to the occurrence.
yes,
Sir.
they are
They're post-occurrence
they
witness.
are post occurrence witness.
Yes.
They are,
Admittedly, they are post-occurrence witnesses. Having heard the hulla, they have come. By then, it is over. Next.
PW there is also recovery and also recovery of the weapon of offense.
Right. Court said.
Court said.
Yeah.
Court said is a open place.
Ah.
It is accessible to all. So the recovery of the weapon of offense from the court said
So
cannot be relied upon.
So which particular place he got it?
From the court said.
No, come to the evidence of IO. Where from he got? Court said is the place. But
Place.
Was it concealed somewhere or it was just kept on the wall or it was lying on the
It
ground?
was lying on the court. Here,
Ye koila.
PW4.
Where is that? Come to PW4. On the very day, police took the incriminating articles.
The accused, while in police custody, led the police to the house and gave a recovery of the Gauda from the court set. And the said weapon was seized in my presence. Exhibit 9 is the seizure list.
Where is your question to that effect? That the place from where the Gogada was seized was seen to everybody who is in an open place. Where is
There
that?
is no.
You are not putting any question without evidence. How can you, without foundation, you can't have an argument, sir. It must be brought in the evidence first. In absence of an evidence, you cannot presume everything. There should be an evidence to that effect. Because witness is present before you. When he said that it was seized, you could have put a question to him. You did not put a question, now you are arguing it. You cannot. You can argue only when the material is before the court and the court has not taken account of that at the time of trial. Can we put an argument when the evidence is not there?
No.
So there is no question put to the witness as to from which particular place or that the place from where this Gagada was seized is an open place, open to everyone, could be seen in naked eye, even without the instance of the accused. This could have been a question. All right. Next.
As regarding to the confession,
Right.
PW5 says that
Exhibit কে আছে confession টা? Come to exhibit page 52. Please see page 52.
page 52.
Yes.
My lord, 52 is the
27 evidence.
Evidence of prosecution of PW4, my lord. There is no confession.
Oh,
No, PW5.
Lower court.
PW5.
Yes.
I'm placing the evidence of PW5.
Oh.
The accused is my son. I address the accused. Rukubaya Gasni is my daughter. This is Ratni is my wife. The incident took place 3 years back. On that day, I was absent. I had been to Dangat to plow the land. Gasni came and told that the accused Rukubaya committed murder of my wife and little baby, and my wife did not provide rice to him. Hearing the information, my daughter and I immediately rushed to the spot. On reaching the spot, I found the serpent and the other villagers available there, and my wife and the male baby lying, having injuries in the neck. Thereafter, police came and accused before him confessed that he killed his mother, and she did not provide him rice. The accused has not treated in the hospital for his mental disorder. He was moving here and here around without moving around without any doing any work. Cross examination by defense. The accused was suffering from mental disorder 3 years after his birth. For this reason, people calling him as Baya. I have not seen the assault. When I came with my daughter, I found Arjuna Naik present in the house. It is not the fact that I did not tell anything to the accused. It is not the fact that basing upon statement of the daughter I am deposing falsehood. My lord, PW8 says that the accused confessed before him in the police custody, but PW5 states that the accused confessed before him and his brother.
Police came. See, police came later. So this is
Yes.
already a confession made by
Made
the
before
extrajudicial confession. This is extrajudicial confession.
Yes, this is extrajudicial confession.
Yes. What is the wrong? He made the confession before his father.
But the PW says that he has made it in.
No, that is 27 is different. Being in custody, he made confession with regard to the concealment of the weapon of offense. 27 is not for confession. This confession. This is extrajudicial confession.
But it is not stated that it is extrajudicial confession.
Who will say, sir?
It is yes, it is stated
No,
that.
who will say? Extrajudicial confession, who will say? You can infer it from the circumstance that this is an extraordinary. Or if someone has to say that this is an extra confession, extrajudicial confession. Extrajudicial confession has to be inferred from the circumstance. When the accused voluntarily make a statement before the third party whom he reposed confidence that yes, I can divulge before him. So the confession has been made before the father. Who else would have been better person for this? And thereafter the police arrived, took the accused to custody.
No, he arrested accused at 9 p.m.
All right.
My lord, also I'm
All right. So what is harm in it?
no. There is also discrepancy in the time of the arrest of the accused.
What is there? Apprehension and arrest is two different things. Why do you try to do that? Mr. Mahanti, the accused was there and he has been shown arrest, and after the arrest, 27 has been recorded. Right way. It is not necessary that immediately the person apprehended has to be shown as arrested.
There is to
It
be
is
a
only a
particular time, my lord. There is a
After a
particular time.
preliminary inquiry, if prima facie case is made out against him, only he will be taken as arrest. Why before that? Merely because the accused is available before everybody, why arrest will be made then and there?
My lord, he has also.
Who has said that he was arrested at IO said?
Yes.
IO said that he arrested at 9 p.m.
9 p.m. But in the
At page, kindly come to the evidence of IO. IO is BW
8.
BW 8.
Para 8.
I examined the eyewitness.
On the same day at 9 p.m., I arrested the
Accused person. But PW. But
Yes.
PW4 states that the accused was arrested at 11 a.m.
Accused 4 is a layman. What is arrest, what is apprehension, he can't distinguish it, sir. Only paper can say.
Paper says that the accused was arrested at in the charge sheet. It is shows that the time of arrest is 11 p.m.
Who? Who is saying?
The charge sheet says so.
Where is that? Come to charge sheet. Yes, Mr. Tripathi, where is that?
Oh, 9 p.m. Apprehension of the accused. তারপরে immediately তারপরে আছে the recording of the statement of the 7. তারপরে procedural 10টা হয়েছে।
No, case diary is very clear. Case diary is showing at 9 p.m. and thereafter the statement under 27 has been recorded. It is consistent.
7 time করছি।
Time is there. Yes, next.
I also
We take note of that. Next.
the weapon of offense Gagada,
Hmm.
which was sent by the forwarding report
Right.
by the police, but no serological report is there. Even does that report that Gagada belong to the accused or the blood grouping of that strain
So
belongs.
In absence of a serological report, how do you say that the evidence of the child witness is to be ignored?
Yes.
Merely because the serological report is not before the court, can the eyewitness account is to be discarded?
Yes, my lord.
It is to be discarded.
That blood strain, some blood strain might have been there in the Gogada.
No, not might have been. Has the police said about it? At the time of seizure, what is there? Is this reporting?
Yes, that is page 64, my lord.
Page 64.
Yes, sir.
64 is the forwarding.
Yes,
Hmm.
the other things.
No, finally the report has come.
Report is not available.
It did not come that.
So also the
Even did not come to the court. All right. That means there is no serological effect. All right.
so also the tangia and the rice was also not seized from the accused, which is stated in the FIR, and so also by PW4. The tangia.
No, PW4 is saying about Gagada. In
No,
the FIR, it is mentioned at Tangia.
Tangia also.
And he is not an eyewitness to the occurrence. The person who scribed the FIR is not a eyewitness to the occurrence, and he said about
He
the
was
Tangia.
also a post-occurrence witness, and he died because
Yes.
I could not be examined.
The seizure witness, PW4, has stated about Gagada. The eyewitness has stated about Gagada.
Eyewitness also identified
It. Doctor also stated about Gagada. So there is an examination of this weapon of offense. Or a suggestion has been put to the doctor. Kindly come to the evidence of doctor.
PW1.
On 23/7, I got a requisition from the CI Pradhani, Papada Handi, with the weapon of offense for its examination, whether the injuries are yes.
Exhibit.
Yes.
Positive opinion.
Yes, positive opinion.
But here he says that the injuries are possible by the said open, not both the disease. But in the cross-examination, it was asked the injuries mentioned in my report can be possible by fall under sharp cutting.
Now that foundation you have to lay. You have to lay that foundation that the entire episode has taken place on falling on the ground. That is your case.
Yes.
So only a suggestion to the medical witness is enough. The suggestion which you are giving to the witness must be your foundation for the entire plea, defense plea. So what is your defense? That the person died of the injuries suffered by fall. That is your case.
Yes. No,
Got injuries are there. That is your case right from the beginning. This is the suggestion you have given to everyone.
No.
So your plea should be a consistent one right from the beginning till the end. And also to support your plea, you have to take a defense plea. Here a suggestion, a sporadic suggestion to the witness, medical witness, that this could be possible by fall is not enough to say, not to doubt the veracity of the testimony of the witnesses.
But the plea of insanity was also taken by the defense.
If that is so, what petition you have filed before the court? Did you ask for a medical examination?
No, I have not.
You didn't do anything, and you are simply arguing, sir.
But
no step has been taken from your side, and you are arguing which the matter is not before this court. How can the court appreciate?
But one decision is there. AIR 2009 Supreme Court S.K. Yadav versus State of Maharashtra. The onus of proving the unsoundness of mind is on the accused. But where during the investigation of previous history, insanity is revealed,
Uh,
it's the duty of the investigator to
Sir, you are going on reading the decision. Is it your fact? Is the investigating officer found that the person is insane? Is there any material to that effect? So insanity has to be proved by you. If this plea has been taken all through by you and a medical report, have you examined the doctor who has examined the accused, showing that he was insane? So all these materials are not there. You are only arguing in air. So the basic principle that whatever argument you are placing before the court must find place in the case record. Otherwise, how the court will reappreciate the evidence? We are reappreciating the evidence. It is a continuation of the trial. We are reappreciating the evidence. So in absence of any material in the court or before the court, how this court will reappreciate? So there is no evidence. Yes, next, Mr. Monty.
My lord, I pray that the accused has already undergone 17 years of, and he may be released on 304 part 2 IPC.
What is the ingredients of 304 part 2?
It
Where is
the
the
attack,
sudden provocation?
sudden provocation is
Where
there.
is that?
I,
Who has provoked?
sudden
They
provocation
were,
means
he asked,
he asked for rice,
he asked for rice water,
rice water,
and
and due to non pro, this,
the
the
mother
disease
did,
did not
the
provide.
mother did not
Therefore,
provide it.
there was some altercation between the.
Nothing has come. Nothing
Yes,
has
yes, it is there.
come. Anyway, it has come. So where
Yes,
is the provocation? Who provoked whom?
oh, due to sudden anxiety, he has done this. So,
You are
rash
again
of blood, he
debating.
has done this. So, I pray that he may be released on already 17 years. Yes.
We expect, keeping in view your experience in the practice, the manner of argument should be very robust. It can't be here and there, which is not there in the record. It can't go like that. We are sitting in an appeal. Anything more?
No.
Okay. So serological report basing on which you wanted to take an adjournment,
Yes.
that is no more in record at all. So the court has not relied upon it. All right. Yes, Mr. Mahathi. Yeah, Mr.
Yes.
Tripathi.
My lord. First thing first, the eyewitness, my lord, PW3. You have lots of already gone through the evidence of PW3. That is corroborated with the PW1, the doctor, as well as the post-occurrence witness, PW4, PW5, and PW2, my lord. It is corroborated with them. Second thing, my lord, he had on leading to discovery that part PW8 has categorically stated that it was fixed in a concealment place and it was taken. Your lordship, kindly have a glance to PW8, page 60, para 10 units. I see, shall I please?
Yes, yes.
Then I seize the Gagara, the weapon of offense, as the accused, that is the IO and the witness to the place of concealment produce the same. The same was seized in the presence of witness, Arjun Naik and Murli Naik, prepared sigilist, and the place of
Muralidhar Naik
concealment.
is examined.
Muralidhar was the informant, my lord. He died.
Oh, he
in the
died.
meantime.
Right. So Arjuna has been examined.
Arjuna Ektan is PW4,
Right.
your lordship. He has stated. So there is no doubt in the recovery of the weapon also. And the third thing he has placed regarding the C report, that is not available.
That's
And the fourth thing, the mental condition, what he is
yes.
saying. To that effect, my lord, your lordship, kindly have a glance to page 25 of the judgment. Court has categorically said that, page 25 of the judgment, I'm placing the person. No abnormality was no abnormality was there by the court while the accused standing in the dock. The defense has also not produced any evidence to support his plea of insanity. Even he has not taken plea during the course of accused statement. recorded under section 313 CRPC. Rather, he pleads complete denial of the effort.
That means the court being the first, at the very first instance,
Well,
found the demeanor of the accused to be fine.
yes.
No insanity is found in him. No plea has been advanced by the defense. No such material has been produced before the court.
And
Yes.
also, in page 23, my lord, last 1, 2, 3, 4, 5, 6, 6 line from the down. Accused are suffering from legal injury. The accused appeared to have confessed his guilt before his father and the police in presence of witness. He is also served in the jail custody for a definite period. Nothing abnormality was found by the jail authority during the space of his detention. There is a hospital in the jail. Such treatment was meted out of his request by the medical person attached to the hospital. While in jail, behavior is normal and having good demeanor shown by him to other inmates. He also never
Actually,
complained of any
Mr.
abnormality.
Tripathi, the law is that to establish a defense on the ground of insanity,
He has to
it
admit
must clearly be proved that at the time of committing the act,
Not
the
That is
accused
also
was laboring under such a defect of reason from disease of mind as not to know the nature and quality of the act he was doing, or if he did know it, that he did not know he was doing what was wrong or contrary to law. ତେଣୁ that very point of time that is relevant. ଏଠି ଗୋଟେ evidence ଅଛି ସେ ଗୋଟେ ପିଲା ବେଳେ 3 ବର୍ଷ କଣ ପାଇଁ ଟିକେ ଇଏ ଥିଲା ସେଇଥିପାଇଁ ତାକୁ ବାୟା ବାୟା ବୋଲି ଡାକୁଥିଲେ. So that would not be relevant. ଜଣେ accused ଯେତେବେଳେ ଗୋଟେ crime କରିକିନି ତାର weapon of offense କୁ ନେଇକିନି ଯାଇକିନି ଗୋଟେ ଜାଗାରେ conceal କରୁଛି ହେଲା ଆଉ ଚାଉଳ ନେଇକିନି ଯାଉଛି ଯେ ଯଦି କୋଉଠି ହବ ମୁଁ ବହୁତ ଦିନ ଧରିକି ରହିଯିବି ଚାଉଳ ନେଇକିନି ସେଭଳିଆ ଲୋକଟାକୁ at that point of time can it be said that he was
oblivion of the act that he did.
that is also insanity also. So
If the accused has absconding, therefore, how he was arrested on the same day at 11 a.m.
No,
and he was present and confessed
no
the guilt
evidence is that he came back.
before the extrajudicial confession.
He was
If he
seen
has the
going,
intention,
but he came back.
if
He
his
was seen
mental
going.
condition is good and enough, that he should have absconded somewhere. The police couldn't have find.
who know what has struck to your mind once you have killed your mother and your
Own brother,
own
child.
brother minor might have that repentance come to your mind afterwards that what I have done was not correct. So for that you return to your and you are arrested. So merely because you did not abscond, that doesn't mean that you are neither involved in the crime, number one, and that you have no intention to commit the murder. And what is the that argument which you are advancing about 304 part 2? Have you seen that what my esteemed brother pointed out? What was that nature of quarrel? What was that provocation? And what that
Provocation-
child did to you? That your
child-
younger brother, which is child of 18 days, what he did to you? Your mother, it's all right. Your mother did not provide you that soaked rice. ପେଜ ଦେଲାନି ଆପଣ ମାଗିଲେ ପେଜ ମାଗିଲେ ପେଜ ଦେଲାନି ତ ଛୋଟ ଛୁଆଟା କଣ କରୁଥିଲା ଆପଣ ନିଜ ସାନ ଭାଇଟା 18 ଦିନର ସାନ ଭାଇ ତା ବେକଟା କାହିଁ କାଟି ପକେଇଲେ ତେଣୁ ଆପଣଙ୍କର ପାର୍ଟ କୁ ମାରୁଛନ୍ତି କୋଉ ବଡି ପାର୍ଟ କୁ କୋଉ ୱେପନ ରେ ମାରୁଛନ୍ତି ଏବଂ କୋଉ ଫୋର୍ସ ରେ ମାରିଛନ୍ତି ଭିତରକୁ ପଶିଛି 4 ସେଣ୍ଟିମିଟର 4 ସେଣ୍ଟିମିଟର ଟା କିଛି କମ ନୁହେଁ so everything has to be taken into account. You have remained in custody for 17
years.
That is the lookout now of the government to see your conduct and whether your case will be recommended for premature release or not.
That is, their provision is there under 433A. So there are guidelines framed also in that respect. So the state government has to take into account.
On the basis of recommendations, so recommending authorities are there.
Or which number item is 39? List of 39. Heard Mr. Prem Kumar Mahanti, Land Council, appearing for the appellant, and Mr. Rajesh Tripathi, Land and Additional Standing Counsel. Hearing is closed, judgment reserved. You have been engaged by this court or by the legal aid?
No, I have been into the court.
Court.
The court.
Yeah, legal aid.
Legal.
Aid.
Because if we would have engaged you as amicus curiae, the matter is different. Otherwise, there is a payment schedule of the legal aid board.
Legal aid.
So, Mr. Tripathi, any other matter there? No, death reference, we want to commence it from, because Monday, Mr. Panda, you are ready with your note of argument, etc. No, you have to place you. It's a death reference case, a written note of argument, memo of citations, and there should be two memo of citation on the merit of the case, memo of citations on the death sentence itself. So, what is this case? Rape and murder?
Murder.
Only murder.
Murder.
How many persons?
Two persons have been murdered.
Ah.
2 persons have been injured.
Okay, that is the case. So,
That is case.
okay. So, and your accused persons are they are appearing to that order has been passed. Which jail there? Hey,
ಹುಡುಗ
The
ಹುಡುಗರ jail
convicts
nahi
are
bothi.
in which jail?
I mean, pardon?
The convicts are in which jail?
Must be Nayad jail.
why arrangement has not been made?
This is your item number is?
Item 6, man.
No, in death reference cases, we are providing link to the accused persons who are in jail to watch the proceeding. Not only that, we are asking the land and district judge to depute a state council to remain present with them and to apprise them what is going on here, your argument, and if he wants to tell anything to you, that will also be communicated by the council present there to you. So, Nayagarh jail. So make arrangements so that it can be, they will be there. CP को କହିଦେବେ can instruction by register judicial କହିବେ instruction ଦେଇକିନି ସେ କେତେ ଜଣ accused?
ଜଣେ
ଜଣେ.
ଜଣେ.
He should remain present and one of the state council should remain present. ହେଲା? We'll take up that matter on Monday.
Our remand lawyer thibe.
Monday, get prepared and
I beg pardon. I was got but absolutely no cross
ये live streaming talk.